The House Oversight Committee has voted to subpoena Attorney General Pam Bondi to appear for a closed-door deposition as part of its investigation into Jeffrey Epstein. Republican Congresswoman Nancy Mace introduced the motion, saying she wants Bondi to address why videos, audio, logs, and interview notes remain missing from the files that have so far been released by the Department of Justice. The Attorney General did not immediately respond to requests for comment. For more on this, let's bring in the publisher of the Watchdog Report on Substack, Kurt Bardella. Kurt served as the former spokesperson and senior advisor for Republicans on the House Oversight Committee. Kurt, good to see you. You obviously have experience in this world. Give us your reaction. Was this a surprise, this move here for Attorney General Bondi? What do you think it will yield?
What's happening, friends? Dr. John here with another big episode. The rule of law just suffered another direct and deliberate blow at the hands of the very people who swore oaths to uphold it. Donald Trump's recently terminated Attorney General, Pam Bondi, simply decided that a lawful congressional subpoena did not apply to her.
Well, it's interesting, the timing, right? After we just had the depositions of Bill and Hillary Clinton, it kind of opened the door, really the floodgates for other members to say, listen, if the committee's going to spend time, resources, going all the way out to New York to interview former President Clinton, former Secretary of State Hillary Clinton, why on earth are we not hearing from people who have active eyes and ears on the Epstein files, who are in control of the flow of information or lack of information in some cases that's coming out? Members of Congress on both sides of the aisle are frustrated with the redactions, with files going up, files being taken down, other media entities doing investigative work, coming up with information that the committee doesn't actually have in real time. So frustration.
She was scheduled to appear before the House Oversight Committee for a deposition that would have required her to answer questions under penalty of perjury about her role in the systematic concealment of Epstein-related documents. She did not show up. She did not seek a court order quashing the subpoena.
Finally reached this boiling point. And you saw yesterday a bipartisan. I mean, this is an incredibly rare thing to have right now in this highly narrow majority that Republicans have. A bipartisan group of members voted to subpoena the Attorney General, blindsiding the chairman, James Comer, at the start of his hearing yesterday, to the point where he had to kind of punt that vote to later in the day to figure out what the real was. And it ended up having 5 Republicans join every congressional Democrat on that committee to vote for Bondi to come and start answering questions. And the key thing here, the most important thing about this, is it's a closed-door deposition. It's not a public hearing. She will not be able to grandstand and filibuster the way she did in the Judiciary Committee meeting a few weeks ago. This is a time where you have unlimited amounts of time. There's no 5-minute rule. There's no, I only have a few minutes to get my question in, so you can run out the clock on me. It's a deposition. The Clintons sat for 8 hours last week on tape. She's going to have to do the same thing. So if she decides to just monologue away, bring up extraneous things, fight back against those answering questions, the person there is going to say, okay, that's nice. Answer the question. We got all day.
She did not negotiate a mutually agreeable alternative date through proper legal channels. She unilaterally canceled her appearance as though a subpoena issued by the United States House of Representatives carries no more legal weight than a dinner invitation she was free to decline.
Yeah, it'd be very interesting to watch as we go forward. Kurt, so you're in Dallas, so we want to talk to you about Texas. In the Texas Republican primary for U.S. Senate, incumbent Senator John Cornyn and Attorney General Ken Paxton are now headed for a runoff on May 26th. And then late yesterday, President Trump, who sat out the early stages of the primary, well, he posted on Truth Social that he will soon endorse one of the two candidates and insisted that whichever candidate he does not endorse must immediately drop out of the race. Thank you for your attention to this matter, the president said. Paxton, however, quickly said that he would not drop out, no matter whom Trump backed. So
let us be perfectly clear about what a congressional subpoena represents in our constitutional system. It is not a request. It is not a suggestion. It is not an optional summons that recipients may honor or ignore based on their personal convenience or their assessment of the political implications of their testimony. A congressional subpoena is a compulsory legal instrument backed by the full investigative authority of a co-equal branch of government.
Kurt, there's been some reporting that the operation around Trump is really steering him towards Cornyn for the endorsement. That's expected. But talk to us about this dynamic, that especially if, let's say that happens, and Paxton doesn't drop out. Well, that's a 2.5, almost 3-month primary that could get ugly and expensive. Meanwhile, Democrats, this is the best they felt about Texas in a long time.
Yeah, this is the best case scenario really for Democrats. Tallarico was declared decisive winner. He has open road ahead of him while Republicans try to figure this out. And if Paxton doesn't get out after Trump endorses Cornyn, it could be a very bruising 12-week period in which Republicans will have to spend their financial resources, time, and oxygen fighting amongst each other while they won't be able to lay a glove on James Tallarico. He'll get to spend the next 3 months sailing, doing what he wants to do, having his own message, raising resources and allocating them to benefit him, raising his name ID, running a positive campaign rather than having a Republican just feather and tar him and try to beat him up and down the Lone Star State. It's an open field and open road. That is the ideal scenario if Democrats are going to flip Texas. And you look at the numbers that have come in and the ways in which the Hispanic vote completely abandoned the Republican Party. We're looking at counties in which Republicans, had less votes than Democrats when it came to the Hispanic vote. That's a huge swing from what we saw in 2024.
When a recipient refuses to comply without securing judicial relief from the obligation, that recipient is engaging in contempt of Congress. That is not a political characterization. That is a legal description of conduct that violates specific federal statutes, and that carries potential consequences, including criminal referral to the Department of Justice. Pam Bondi's defense, such as it has been articulated through various channels, rests on a claim that her recent termination as Attorney General somehow extinguishes her obligation to comply with a subpoena issued in her name. This argument collapses under even the most cursory legal scrutiny. A subpoena attaches to the person, not to the office they currently hold. If an individual receives a lawful subpoena while serving in a particular position, their subsequent departure from that position does not retroactively nullify the legal obligation they incurred. The subpoena commands the person to appear and testify. It does not command the office of the Attorney General to produce its current occupant. Pam Bondi was subpoenaed. Pam Bondi remains obligated to appear. The fact that she is no longer Attorney General is legally irrelevant to the validity of the subpoena and to her duty to comply. The contrast with previous high-profile figures who have faced congressional subpoenas is instructive and devastating to Bondi's position. Hillary Clinton appeared for her deposition. Bill Clinton appeared for his. They sat in those chairs, faced questioning, and navigated the proceedings as the law required. They did not claim that their status as former officials immunized them from congressional oversight. They did not announce that they were simply too important or too besieged to honor lawful process. They showed up because that is what the law demands, and what any attorney, especially one who has served as the nation's chief law enforcement officer, should understand as non-negotiable. Pam Bondi, however, appears to have internalized a different lesson from her tenure in Trump's orbit. She seems to believe that the rules that bind ordinary citizens and even former presidents and secretaries of state simply do not apply to those who serve as instruments of Trump's will. She appears to operate from the premise that her proximity to power, even power she no longer formally holds, confers a kind of immunity from the ordinary obligations of citizenship. And the Republican members of the House Oversight Committee, rather than defending their institution's constitutional prerogatives, have actively facilitated her defiance. Democratic Congressman Robert Garcia, serving as ranking member of the Oversight Committee, issued a statement that captures both the legal reality and the appropriate institutional response. He declared that Pam Bondi is evading a lawful congressional subpoena by failing to appear before the committee for a deposition concerning the Epstein files and the White House cover-up. He emphasized that the subpoena applies to her regardless of her title, and he announced that if she continues to ignore the law, oversight Democrats will move forward with contempt proceedings immediately. This is not performative outrage. This is the constitutionally prescribed mechanism for addressing exactly this form of executive branch obstruction. When a witness refuses to comply with a lawful subpoena, the committee has the authority to hold that witness in contempt and to refer the matter for prosecution or to pursue civil enforcement through the courts. These are not extraordinary measures reserved for exceptional circumstances. They are the ordinary tools Congress possesses to vindicate its investigative authority against those who would treat it as optional. Congresswoman Melanie Stansbury reinforced this position with equal clarity. She stated that Bondi was subpoenaed to appear, and that this was not a request but a legally binding congressional subpoena. She made explicit what Bondi's defiance implies, that if arrangements to appear are not made immediately, contempt proceedings will follow. The language is precise because the legal situation is precise. There is no ambiguity about whether a subpoena creates an obligation. There is no gray area about whether a former official can ignore congressional process. The law is clear. Bondi's obligation is clear. Her defiance is clear. The only question is whether Congress will enforce its own authority. The Republican response to this situation reveals the depth of their complicity in the broader cover-up. Rather than defending the institutional interests of the legislative branch they serve in, rather than insisting that executive branch officials, current or former, cannot simply ignore congressional subpoenas at their convenience, Republicans on the Oversight Committee have chosen to attack the Democrats seeking to enforce the subpoena. They have accused Congressman Garcia of hypocrisy, pointing to the Clinton investigations and claiming that Garcia said nothing when the Clintons defied subpoenas for months. This comparison collapses on multiple levels. First, the Clintons actually appeared for their depositions. Whatever procedural disputes may have surrounded those appearances, whatever delays may have occurred in the scheduling process, the fundamental fact remains that they showed up and testified. Pam Bondi has not shown up. She has unilaterally canceled. The distinction between disputing the scope of a deposition while still appearing and simply refusing to appear at all is the distinction between engaging with the legal process and treating it with contempt. The temporal proximity of Bondi's service as Attorney General to the events under investigation makes her testimony uniquely relevant and urgent. She was terminated mere days ago. The Epstein document cover-up is not ancient history being excavated by historians. It is an ongoing obstruction of justice occurring in real time. The documents she can testify about, the conversations she participated in, the decisions she witnessed or made regarding what to disclose and what to conceal, these are not matters of historical curiosity. They are active components of a continuing effort to prevent Congress and the public from learning the full truth about what the Epstein materials contain and why the Trump administration has fought so ferociously to keep them hidden. The Republican invocation of the Clintons also serves a more insidious purpose. It is designed to muddy the waters, to create false equivalences, to suggest that everyone does this so no one should be held accountable. This is the classic strategy of those who have no substantive defense. When you cannot justify your own conduct, you point to someone else's alleged misconduct and insist that selective prosecution or political bias explains why you are being singled out. But Bondi is not being singled out. She is being treated exactly as any former high-ranking official who defies a lawful subpoena should be treated. The fact that other officials in other contexts may have received different treatment, if that is even true, does not excuse her defiance. Two wrongs do not make a right, and the claim that someone else once got away with something does not create a legal entitlement to get away with something oneself. Acting Attorney General Todd Blanche appeared on what can only be described as state media to defend the administration's position. His arguments track the same pattern that has characterized this cover-up from its inception. He claims that the administration is complying with the law by withholding documents that the law supposedly permits them to withhold. He invokes a laundry list of privileges: attorney-client privilege, work product protection, deliberative process privilege, classification restrictions. Each of these doctrines has legitimate applications in appropriate circumstances. None of them creates a blanket immunity from congressional oversight. None of them authorizes a witness to simply ignore a subpoena, rather than appearing and asserting valid privileges in response to specific questions. The privilege assertion strategy reveals the administration's broader approach to accountability. They are not engaging in good faith negotiations about the scope of disclosure. They are not identifying specific documents that implicate particular privileges and seeking judicial resolution of any disputes. They are invoking every conceivable privilege simultaneously to justify withholding tens of millions of documents, a volume so vast that it cannot possibly reflect a careful, document-by-document privilege analysis. This is not compliance with the law. This is using the language of legal privilege as a shield behind which to hide evidence of misconduct. The deliberative process privilege, in particular, has been stretched beyond recognition in the administration's arguments. That privilege is designed to protect the candid exchange of views among policymakers as they formulate government decisions. It is not a mechanism for concealing completed actions, for hiding evidence of potential crimes, or for preventing Congress from investigating whether executive branch officials complied with their legal obligations. When the privilege is invoked to withhold tens of millions of documents related to a matter of intense public concern, the invocation itself becomes evidence that the administration has something significant to hide. Pam Bondi's previous appearance before the committee, offered voluntarily and without the constraints of sworn testimony, provides additional context for understanding her current defiance. She was willing to appear when she could control the format, when she could speak without facing penalties for false statements, when she could recite Trump talking points rather than answer specific questions about specific documents and specific decisions. But when faced with a deposition under oath with the legal consequences that attach to perjury, she has chosen defiance over transparency. This pattern is familiar to anyone who has watched the Trump orbit navigate legal accountability. They are eager to speak when the forum allows them to control the narrative and avoids legal exposure. They become suddenly unavailable, suddenly claiming privilege, suddenly asserting that process does not apply to them when the forum requires truthful answers under penalty of law. The mafia-style warning that Trump delivered to Bondi before her termination deserves particular attention. In public comments, he praised her as terrific while simultaneously delivering what can only be described as a threat. The message was unmistakable to anyone familiar with how Trump manages his subordinates. Loyalty is rewarded, defiance is punished, and the punishment is not merely professional but potentially legal and reputational. Bondi understands what happens to former Trump associates who cooperate with investigators. She has watched Michael Cohen face prosecution. She has watched others navigate the wreckage of careers destroyed by Trump's wrath. The warning was not subtle, and her subsequent defiance of the subpoena suggests she received the message clearly. The contempt proceedings that oversight Democrats have promised represent the next logical step in this confrontation. If Bondi continues to defy the subpoena, the committee will vote on a contempt resolution. That resolution, if adopted, would refer the matter to the Department of Justice for criminal prosecution, or would authorize the committee to pursue civil enforcement through the courts. Either path presents complications. Criminal referral to a Justice Department, now led by Todd Blanche, who has already demonstrated his commitment to protecting the administration rather than enforcing the law, seems unlikely to produce meaningful consequences. The department that is actively concealing documents and defending Bondi's defiance is not going to prosecute her for that defiance. Civil enforcement through the courts offers more promise, though it operates on a timeline that may extend beyond the current political moment. Federal judges have demonstrated willingness to enforce congressional subpoenas against executive branch officials who claim immunity. The precedents are clear. Congressional investigative authority is broad and essential to the functioning of our separated powers system. Executive privilege is not absolute and cannot be invoked to shield potential misconduct from any scrutiny whatsoever. The courts can and do resolve these disputes, and when they do, they typically reject the most expansive claims of executive immunity. But the judicial path requires patience that the current political calendar may not afford. Litigation takes months or years to resolve. Appeals extend the timeline further. By the time a final judicial determination issues, the political moment may have passed, the public attention may have moved elsewhere, and the practical consequences for Bondi may be minimal. This is the strategic calculation that underlies her defiance. She is betting that the process will move slowly enough and the political winds will shift quickly enough that she can simply outlast the subpoena. The broader Epstein document cover-up, of which Bondi's defiance is merely one component, represents one of the most significant transparency failures in modern American governance. Multiple federal judges have ordered the release of these materials. Congress has enacted legislation, the Epstein Transparency Act, specifically requiring disclosure. The administration has fought compliance at every turn, invoking privileges, filing appeals, slow-walking production, and now, through Bondi's defiance, simply refusing to allow key witnesses to testify under oath about what happened and why. The question that hangs over all of this is simple and devastating. What is in these documents that justifies this level of obstruction? What could possibly be so damaging, so explosive, so threatening to the administration's political fortunes that they would risk contempt proceedings, judicial sanctions, and the sustained outrage of transparency advocates rather than simply comply with lawful disclosure obligations? The only logical answer is that the documents contain information that would fundamentally undermine Trump's political standing, reveal criminal conduct, or both. Innocent people do not fight this hard to conceal evidence. People with nothing to hide do not invoke every conceivable privilege to prevent disclosure. People acting in good faith do not instruct their former Attorney General to defy lawful congressional subpoenas. The House Oversight Committee's Republican members, by facilitating Bondi's defiance, have made themselves active participants in this cover-up. They are not neutral observers waiting for legal process to resolve disputed questions. They are using their positions on the committee not to conduct oversight, but to prevent it. They are deploying their institutional authority not to vindicate congressional prerogatives, but to shield the executive branch from accountability. This is not what oversight means. This is not what the Constitution contemplates. This is the conversion of a legislative check on executive power into an instrument for executive protection. The contempt proceedings, when they come, will force every member of the committee to take a public position. Those who vote to hold Bondi in contempt will be defending the institutional interests of Congress and the principle that no one is above lawful process. Those who vote against contempt will be announcing that they value partisan loyalty to Trump more than they value their own institution's constitutional authority. That vote will be recorded. It will be cited in campaign materials. It will be used by primary challengers and general election opponents. And in districts where swing voters care about rule of law and institutional integrity, it will matter. Pam Bondi's calculation that she can simply ignore a subpoena and face no consequences reflects a broader degradation of legal norms that has accelerated throughout Trump's political career. Each time a norm is violated without consequence, the violation becomes easier the next time. Each time a subpoena is ignored, the next subpoena carries less weight. Each time a privilege claim is stretched beyond recognition, the next claim can be stretched further. The cumulative effect is the erosion of the entire structure of legal accountability that distinguishes democratic governance from authoritarian rule. The fact that Bondi was recently Attorney General makes her defiance particularly corrosive. She was the nation's chief law enforcement officer. She swore an oath to uphold the Constitution and the laws of the United States. She presided over a Department of Justice that routinely issues subpoenas and expects compliance. She understands, or should understand, exactly what a subpoena is and what obligations it creates. Her refusal to honor one directed at her personally sends a message that the law applies to ordinary citizens, but not to those who have served at Trump's pleasure. That message, if allowed to stand unchallenged, is fatal to the principle of equal justice under law. The contempt proceedings offer Congress an opportunity to push back against this erosion. They offer an opportunity to demonstrate that institutional prerogatives matter, that lawful process cannot be ignored at personal convenience, that former officials do not escape accountability simply by leaving office. Whether Congress seizes that opportunity or allows it to slip away will tell us something essential about the current state of our constitutional system and about whether the checks on executive power remain functional or have become empty formalities.